Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
Good morning, everyone. My name is Carrie. I'm sure you'll all be very surprised to hear I practice employment law at Devry, Smith & Frank. I'm going to draw our attention away from human rights issues and lead us into the very exciting world of temporary layoffs. My topic is, when does a temporary layoff become a deemed termination? And considering this topic, we have to consider two different areas. One is the Employment Standards Act, and the other is the case law. I'll touch briefly on the Employment Standards Act first, and then we'll get into some of the issues that the case law creates. So first of all, the Employment Standards Act provides in Section 54 that an employer is prohibited from terminating the employment of an employee who's been continuously employed for a period of 3 or more months unless notice is provided to that employee or unless they're paid termination pay in lieu of notice. The Act provides an exception to prescribed employees. A prescribed employee is defined as an employee on a temporary layoff or an employee who is temporarily laid off and does not return to work within a reasonable time after having been requested to do so. So then the Act next defines what a temporary layoff is. Because the employer, so a temporary layoff is a layoff of not more than 13 weeks in any period of 20 weeks. It may also be a layoff of more than 13 weeks in any period of 20 consecutive weeks if the layoff is less than 35 weeks in any period of 52 consecutive weeks. In that case, there's other factors that come into play, so it's not just the timing, but the Act sets out specific requirements that if they're done, that also includes it as a temporary layoff. So the key consideration is if it's more than 13 weeks in a 20-week period, you will have been deemed to terminate that employee, or if it's more than 35 weeks and in a period of 52 consecutive weeks, it's a deemed termination. So that's all set out in the Act. It's supposed to be very, very clear. Where things may be confusing is when we discuss case law, because what happens is that the Employment Standard Act sets out the minimums that employers are required to follow. And just because you have complied with the Act doesn't mean that you have complied with the case law. The case law sets out a whole world of benefits to an employee that are not captured by the Act. So it's not enough for an employer to say, I have complied with the Act, therefore I'm fine. The case law has given employees many, many benefits that are not captured by the Act. So what does the common law say? In the common law, there really is no term of layoff. In the non-union setting, there is it has no technical meaning, and I'm not really touching on any union cases today. I'm focusing more on the non-union situation. So at the common law level, courts have said that there really is no right for an employer to lay off an employee. And why is this? It's because the employer-employee relationship is contractually based. So there's rights and obligations that flow between that relationship. The Employment Standard Act, it doesn't get involved in this contractual relationship. So what are the key points of the contract that you have to consider? The first is that it's in most employment contracts, it's an implied term that the contract will be for an indefinite period of time. That means you don't hire someone and you say, fine, you'll work with us for 5 years, then you're done. They're typically open-ended. And it's usually a fundamental term of an employment contract that you pay an employee. So if you lay someone off, what you're doing is you're ending that indefinite term and you're ending their payment of salary. And what the courts have said is that is essentially a breach of the employment contract, and the employee then becomes entitled to sue the employer for constructive dismissal. even if they've complied with the Employment Standards Act. So how can employers avoid this situation? When you're drafting your employment contracts, you can include terms in it that allow for temporary layoffs. If you put your employees on notice that layoffs are potential in this particular company, if layoffs happen consistently, if employees accept these layoffs, it's really about giving them notice that it's a possibility. The clearest way is to put in the employment contract that this is a potential. So what may an employee do if they are temporarily laid off? Sometimes employees acquiesce. They simply accept that they've been laid off and they wait to be called back, and they're entitled to do so. Some employees are not content to do that, and they may then bring an action for a constructive dismissal and seek damages. And the damages will usually be a request for payment for a notice period. So what does this mean for an employer? When you lay someone off, you may in fact be required to pay them the notice periods set out in the common law. It's not as simple to say, I've laid you off, I've complied with the act, I'm done. If an employee refuses to accept this and they say, no, you've broken my contract, you've stopped paying me, you've breached the indefinite term of the contract, I will sue you for a wrongful dismissal, I will sue you for damages. And that is their prerogative. So if you wish to avoid that, don't use layoffs as a means to get rid of an employee, essentially to terminate an employee without providing them the notice period. And it's not an excuse to say that there's been an economic downturn and I have these various employees that I don't want to pay anymore. If you lay them off for an indefinite period of time, you will eventually, if they bring a cause of action, be required to pay them the notice period. So, and just to give you an example of this, there's a case called Bartolucci, which is, I think it's probably a fairly typical example where an employer laid off an employee once, she accepted it, she got recalled, and eventually she got laid off again. Shortly after she got laid off the second time, and it was for a set period, if it was for 12 weeks, she found out that her assistant had taken on her job duties, and she was concerned that she had no job to go back to. She consulted a lawyer. The lawyer sought confirmation from the employer that her job was still available to her. The employer refused to give her that acknowledgement, so then they brought an action for wrongful dismissal. As the action progressed, the lawyer went back to the employee several times and said, would you please confirm that this job is still available to her at some point? And then the employer came back and said, well, we're going to extend the layoff for a further period. This matter eventually went to court. The judge held that the employee, whether or not she acquiesced previously to the first layoff, wasn't really a factor for the second layoff because she almost immediately said, is my job still available? And she looked for that reassurance and didn't get it. And the court actually found that she had been constructively dismissed. And the employer then said, fine, we'll recall you, but we're going to give you a different job. And the court was not satisfied with that. So you have to be very careful when you lay someone off. If it's going to be for a particular term, stick with the term. If you make it indefinite, they can treat the contract as an end and sue for wrongful dismissal. And trigger all the notice requirements, both under the SA and in the common law. So layoffs can be tricky. Certainly, you may want to consult a lawyer before you decide to lay someone off and then get some advice on whether or not you should do it for short-term, indefinite term. And be sure to consider the fact that there are the ESA requirements, but there's also the requirements of the common law. So I wrapped my subject up rather quickly, and I will hand it over to Chris.